Great. Good morning, everyone. Good afternoon, good evening, depending on where you're joining from. I see the participants slowly coming in. It's great to have you here. My name is Zainab Malik, and I'm really pleased to be moderating this webinar on behalf of the SAME network. Now, just to start off, the SAME network is the South Asia Middle East Network. We're a regional coalition of activists and organizations across South Asia and the Middle East. With we have organized ourselves with the goal of advancing the rights of those under criminal justice systems across the country and to abolish the death penalty. We represent a coalition of actors from Pakistan, Sri Lanka, Saudi Arabia, India, Iran, and we're all united with a common purpose. We hope to create a more human rights-based criminal justice system across the country. Between all of us, we represent some of the highest executioners and some of the worst violators of human rights across criminal justice systems. Now, we're joined here on the International Day for the Remembrance of Victims of Torture. Now, across all of our countries, torture is often hidden behind prison walls and shielded by weak oversight. And yet it remains a systemic and deeply rooted challenge that all of us face in our work. Despite the many differences across our legal systems, cultures, and political contexts, we face strikingly similar realities. This includes custodial violence, a lack of independent investigation mechanism, restricted access to detention sites, and most of all, a failure to uphold international standards like the Istanbul Protocol and the Mendon's Principles, and many others, which a lot of our speakers will be talking about today. Now, this webinar is not just a moment of reflection and sharing lessons learned across the countries. We also hope to create a platform for action. It's really an opportunity to learn from each other's successes, but also from each other's failures, to build regional solidarity, and to push collectively across this region for the implementation of international norms, like the UN Convention Against Torture and the Mandela Rules, and many others like the Istanbul Protocol and the Mendon's Principles that I've already mentioned. So without much further ado, I would like to kick off our excellent dialogue, and I'm really pleased to be joined by some leading voices on the abolition of the death penalty and torture from across the region. Now we're going to start with Pakistan, and I'm really pleased to introduce the first speaker, who is Ms. Sara Belal, who is the founder and the executive director of the Justice Project Pakistan. Now, Justice Project Pakistan has obtained over 40 stay warrants since it started for executions. It's also a leading voice in creating the capacity of law enforcement agency and frontline responders to investigating and documenting torture. One of its great achievements is that between 2006 to 2019, Justice Project Pakistan led a study on the documentation of torture in the district of Faisalabad. They found over 1,424 cases of torture that were documented by a government-appointed medical board. Great. So without much further ado, I would like to hand over to Sarah. But in the meantime, just for our audience, there is an opportunity to ask questions from the speakers. You can use the Q&A tab at the bottom of your screen. So thank you very much. And Sarah, you have the floor.
Hi, everybody. Thank you so much, Zainab. Thank you to OMCT. This Global Week on Torture is just a fantastic opportunity. I would just like to point out, this is one of my favorite panels in the whole world with some of the organizations that from the region that I have the utmost respect from, and I learn from them every single day. So it's an absolute privilege, and this time I really mean it. I'm going to talk a little bit about the cause that JPP has led, engaging with torture and the country and the journey that we've taken, and kind of the opportunities and the challenges we face, which might kind of hopefully give some insight or for others in the region on how we pursue it. So in Pakistan, the scale of the problem is vast. Torture is endemic, it's systemic. However, there are, just to give you an idea, I mean, we had the Faisalabad study, which was 1,800 cases, 1,400 were confirmed. The other ones, didn't have medical testing at that point. That study was used by the CAT committee in Pakistan's first state review, which then led a couple of years later in the concluding recommendation. Based on the concluding recommendations, our National Commission for Human Rights took up that study and did an inquiry, a follow-up report, doing an inquiry in Faisalabad, and then they found that there was not a single police officer in that study had been held to account. And that really created the momentum to ask for a law that specifically deals with torture and criminalizes torture. And in 2022, Pakistan was able to actually pass the law. So now, 3 years into the law being passed, we're in a very interesting time. We're not seeing it play out the way we want it. However, so I'm going to document some of the challenges that we've seen, after this landmark moment where the law was passed. Well, we still have no implementing rules, so delegated legislation that decides how the relationship between how the act and the purposes of the act are going to be carried out. And some of the key features of the act, in line with the Convention Against Torture, is the investigating agency, the oversight has been given to the National Commission, but there's only one word that says supervision, and nothing has kind of been laid out. So there's an absolute confusion between the police, the prosecutors, the agency that's responsible for conducting the inquiries, which is the Federal Investigation Agency, which is also made up of police officers, and the National Commission, on what the extent of their role as supervision entails. Now, what's really interesting is that this, even though we've led many sessions through the National Commission of holding consultations to develop rules that would be in line with all of the standards like the Minnesota Protocol, Mendes Principles, Istanbul Protocol, et cetera, there's a lot of jostling at the federal and the provincial level between these agencies, right? On who gets to do what and what the extent of that is. So we are working with the Ministry of Law and all of the stakeholders at the federal level. But something very interesting is happening is that in the meantime, the Lahore High Court, which is one of the biggest provincial high courts, is inundated with cases filed by lawyers on behalf of litigants. And so we've seen the High Court, I believe right now there's at least 5 going on. And then in the past years, there's been 2, 3 big judgments where they are interpreting the act, but they have very little, I'm going to get disbarred for this, but unfortunately, the High Court judiciary at this point has very little insight into the technical aspects of the Convention Against Torture, the obligations it contains, et cetera, et cetera. And, they've been calling in all these agencies. And finally, and this is what JPP kind of, I will sum it up in the strategy, JPP's had to become party to these acts. And one of the cases were actually lawyers for the National Commission to try to bring some sanity to the process and push back a little bit against all of this jostling, but at the same time expand the understanding of the court relating to this. Now, we did that in these past couple of months, but then there's also soft advocacy. So yesterday, we usually do our events at the federal level, and we realized, no, the crisis and the movement is actually in Punjab. So yesterday we had an event which was called State Accountability. And we had all of the key stakeholders, from the prosecutors to the police, prisons, medical legal experts, lawyers, together on one platform to celebrate the launch of an e-court with the commission to teach public officials about torture. And the linchpin at that event was one of the justices of the High Court, who actually is now sitting on a full bench to the law. And the entire exercise, sort of, was to kind of bring in the judiciary to understand these basic aspects. So that brings me to the second point. Oh, I've already gone over 5 minutes. So I'm going to leave it there, but I'll in the follow-up questions, I'll talk about the capacity building efforts of each individual institution that needs to take place.
Great. Thank you for keeping time, Sarah, and making my job easier. So we heard from Sarah that passing a law criminalizing torture is only the first step. I think it's a really useful lesson to learn because a lot of our advocacy tends to end there. Once we have a law, we consider that the movement is over. But really, JPP's work is showing us that is the beginning and how it's so important to involve law enforcement agencies, but also work in close contact with the national human rights institutions, like we heard about the National Commission for Human Rights of Pakistan. So this really brings me to our next speaker who has first-hand experience doing this. So we're so pleased to invite Miss Ambika Satkunanathan, who is actually the former Commissioner for Human Rights for on behalf of the National Commission for Human Rights of Sri Lanka. Ambika is also currently serving on the UN Voluntary Trust Against Torture. Um, Under her tenure with the National Commission, Sri Lanka also conducted its first prison study, which conducted investigations across 20 prisons and found some really interesting insights, which I'm sure Ambika will share with us today. So, Ambika, handing over the floor to you. Maybe you could tell us a bit more, following up on what Sarah already mentioned, about what monitoring methods have been most effective and how they can be adapted across the region. So please, you have the floor.
Thank you, Zainab, and pleased to be here amongst friends. So I think pre-trial, firstly, the reason that pre-trial or, detention monitoring is really important is because in our region, we find, bail has become the exception. It's not the norm. Pre-trial detainees constitute at least around 60% of our prisons, and administrative detention is being increasingly used and increasingly introduced into new laws. So the National Commission in any country plays a critical role in detention monitoring because they are mandated by law to undertake these visits. But the success of these visits depends on many factors, namely, is the commission independent? It has to be independent in both law and practice because sometimes, it is independent in law, but in practice, it tends to toe the government line. Or in law, it is not independent because the process of appointing members to the commission is not independent and rests solely in the hands of a political authority like the president or the prime minister. Does the commission have legal powers to undertake unannounced visits? Now, for example, in our region, in Bangladesh, it's not possible. In Sri Lanka, the commission can. Does the commission have the power to publicly report on the findings of the visit? Can the commission investigate complaints of custodial violations against the police and the armed forces? Once again, Bangladesh is an example where the commission actually cannot. So when I was at the commission, we found that the inspection process was unsatisfactory because critical information was not being recorded. Sometimes there were not even written reports submitted on the visits. So staff also, there was one instance where the staff we found had informed the prison that we were visiting them in advance, which gave them adequate time to prepare for it. And also simple things like, for instance, the scheduling of police visits. So because the schedule was not changed for weeks and sometimes months, the police stations knew which day of the week and how often the commission would visit and hence be prepared. So this led to the development of standard operating procedures on inspecting places of detention. Zainab, if we can quickly just share screen, the second slide, please, because I'm just going to share the contents page of the manual. So the second screen, yeah, if you can just do full screen. So this is just the contents where you can see for the staff, we had a checklist for the visiting team, even what should they take with them, recorders or camera, etc. The guidelines, interviewing techniques. Then for police station visits, we have particular interview questions. The questions covered everything starting from the arrest process, detention, torture in custody. We had a separate set of questions for police officers and then guidelines for monitoring the conditions. The third slide, please. Then there was a separate section on prison visits. Once again, interview questions, questions on the use of force, then guidelines for monitoring the conditions. Then we had specific guidelines for visiting different centers. So if it was a juvenile detention center, women detention center, immigration detention center. You can stop sharing screen. Thank you, Zainab. The other thing that we did, we found investigating custodial violations is also challenging for NHRIs, the National Human Rights Institutions, because although we don't follow the same evidentiary standards as we would do in a criminal trial, there are still evidentiary standards that have to be followed. So, and we found the staff were not well versed in this. So then for that too, we formulated a manual. Zainab, if we can just share the last two slides, please. So once again, you can see quickly, because we don't have much time. I mean, I'd be quite happy to share this with the document with you separately. We also had, so it was torture in custody. We had for death in prison custody, what they needed to do. We went step by step following the legal process also. Next slide, please. Yes, so death in police custody and death in prison custody. Thank you, Zainab. There are other ways in which the Commission could also undertake not only sort of monitoring, but also engaging with the international mechanisms, which is that the Commissions can submit reports to the UN Committee Against Torture, an NHRI report, when the country is being reviewed by the CAT committee. And also a National Human Rights Institution gets a 1 hour one-on-one meeting with the committee to engage. So that is a positive thing. Then the NHRI can also submit a report to the Universal Periodic Review. And also during Human Rights Council sessions, NHRIs are invited to make statements of 2 minutes. So by doing this, by engaging with the international mechanisms in this way, the NHRI would be creating a safe space for civil society to engage with UN mechanisms and also validate what civil society is reporting to the UN mechanisms. But of course, the problem is, if your NHRI is not independent or is not functioning effectively, what can you do? Well, when the NHRI is being reviewed by the Global Alliance of National Human Rights Institutions to be accredited, because NHRIs are accredited A, B, or C status. So when the accreditation process comes around, civil society can advocate for the NHRI to be downgraded. If it's A, to be downgraded to B, if it's B, to be downgraded to C. But in order to do this, the accreditation committee of the Global Alliance requires evidence of the ways in which the NSRI is not fulfilling its mandate. So to close, 3 points. One is, we're seeing increasingly a number of laws that create space for torture because, counterterrorism laws, narcotic laws, which legitimize the denial of due process rights to arrested persons. And of course, the denial of due process, as we all know, during arrest is the gateway to other custodial violations. The second thing, my point, it leads me to my second point, which is we see increased criminalization as well. And this is where the lens of criminalizing poverty and status, that analytical framework becomes very useful, because we find those who are arrested without due process being respected, those who are tortured often tend to be from marginalized communities. They also cannot retain legal representation, which worsens their conditions. My final point is that in South Asia, there is a general societal acceptance that force and violence have to be used as part of the investigation process, with the common opinion that it's quite all right to rough someone up or to give them a few slaps or cause a bit of pain to force them to tell the truth. So this in turn fuels the general culture of impunity that exists. Hence, no manual, protocol, or law or institution will be successful unless we change these, erroneous, dysfunctional public perceptions and expectations of how the criminal justice system should work. Thank you. I hope I've kept to time.
Thank you very much, Ambika. You've kept the time perfectly. And it was really inspiring to hear your experiences with the National Commission. But also, I'm sure it's given a lot of people in the audience and to our speakers some food for thought on how they can effectively leverage the national human rights institutions in their countries to investigate and monitor torture, but also to serve as a focal point to the different UN bodies to establish accountability. I think we can also, across the region, we've seen the use of extraordinary powers that are granted to governments across specialized legislation like terrorism laws that often provide impunity and an opening for torture. So I think that's something that we'll probably hear from all of our speakers. And just a reminder that we will be taking audience questions after the next speaker, so please use the Q&A tab. We want to make this an interactive space, so we encourage you to pose your questions to the speakers in the Q&A tab. Great. So on this note, we move to India. And I'm really pleased to introduce our next speaker, who is Mr. Anup Surendranath from the Square Circle Clinic at NALSAR University. Mr. Anup, or should I say Dr. Anup, has actually been working on the death penalty since May 2013 in India. And as we heard, it's very difficult to work on the death penalty without looking at this issue of torture and impunity for torture, especially in the context of policing. So Anup and his team at the Death Penalty Research Project actually conducted India's first study on where they interviewed all prisoners on death row, and I'm sure there's a lot of insights that Anup can share with us. So Anup, you have the floor, but my question to you is that you've been working extensively on custodial deaths and deaths in custody, and I understand you have some groundbreaking research that's about to come up. But in your opinion, what are the major barriers to accountability? And really, how have you been using data collection as a basis for systemic reform in India? You have the floor. Thank you so much.
Thanks, Anup, for having me, and it's great to be a part of this panel. What I want to reflect on today in the 5 to 6 minutes that I have is our effort at trying to document custodial deaths and the challenges that even at that basic stage that we face, and towards saying that what are the kind of support mechanisms that we can set up for with families who have suffered custodial death. So our focus is more on custodial deaths rather than custodial torture. It's a sort of a narrow category. But what I want to first focus on is that even in facilitating custodial deaths, I think there is the formal legal regime that there are provisions that allow for arrested persons and incarcerated persons to be exposed to this risk, right? It's in terms of our own law on what are the specific terms on which access to a legal practitioner is allowed, at what stage are you ensured, at what stages of the investigation are you allowed access to a legal aid lawyer or your own lawyer. And I think there are severe limitations there, and those are very important safeguards that the law itself denies, right? It's not even a question of the police practicing it wrong. The second is also the Evidence Act itself that, in the sense, allows for, or in that sense, one may call it, encourages backdoor entry of torture-based evidence. So there is a certain legal provision itself that facilitates this kind of torture in the investigation mechanism, because there is use for evidence generated from such processes in the legal trial, right? So I think there are vulnerabilities that the very legal provisions create. But apart from that, I think of the research that we were trying to do, just like we did with the death penalty, is to say, when we started the death penalty research, we figured that there was no real authoritative sense of empirical evidence of how many death row prisoners there were. And over time, that has been built and developed. And now that is an issue that has been sorted. And we're adopting the same approach for custodial deaths. And I think it's shocking as a system that there is no comprehensive account of how many custodial deaths there are in India in a year, right? There are civil society reports, there are other different or media reports, there are different ways of trying to get a sense, but there is no authoritative sense of how many custodial deaths occur. And we were looking at police custody deaths. We were not looking at judicial custody. In that sense, we were not looking at prison-related deaths when you've been sent to prison by a court. We are looking at police custody deaths. And of course, there is a whole definitional game that has been happening here as to what amounts to a police custody death. Really what we found useful in trying to developed this sense is that of how many custodial deaths happen in India is our the website of the NHRC, right? And we used the National Human Rights Commission. Of course, there are severe concerns with what has been happening to our National Human Rights Commission. But that aside, as a data source, we found only that as a credible source, and using technology, we did automatic scraping of the data that is contained in on their website and their databases. But again, those are severe limitations because not all custodial deaths are coming to the NHRC, right? And the idea really, Zainab, is to say that to build some sort of momentum on accountability for police officers and police personnel who engage in this kind of perpetrating this kind of violence, right? While the NHRC data talks about it, helps you get a sense of what is happening to compensation mechanisms. There is no way for us to tell in our system, despite many efforts to database what is happening in our courts, as to what is happening to criminal trials and complaints in this case, or accountability mechanisms, right? So we are getting an insight to some extent on compensation mechanisms through the NHRC, but the severe limitations that families face when pursuing prosecution is something that remains highly undocumented. And I think we all need to recognize the importance of storytelling and narratives to build a momentum against this, right? And even if our interest really is to develop a system to provide legal assistance to families who want to pursue this, and not just compensation claims, but to want to pursue accountability. But to do that, I think we need to build a robust system of data and storytelling. And without building that, I think it will be very difficult to really make gains in this direction, because even in our law, you need sanction of the government to prosecute a public official. And our recent changes in the laws have at least to some extent improved that by saying if sanction is not provided within 120 days, it is assumed that you can go ahead with the prosecution. But nonetheless, there are very troubling trajectories as far as custodial deaths are concerned. And one is, while the law says a mandatory magisterial inquiry must happen into all custodial deaths, if you look at these magisterial reports, there is a very troubling engagement with causation, right? What caused your death? And all sorts of prejudice creeps into that determination as to whether it was negligence, whether it was torture, what amounts to torture. And through this lens of causation, a lot of legitimate claims seem to be being excluded, both at the NHRC level and at the trial level, right? So in that sense, I would think that it is important to build a mechanism where legal support, in terms of sort of a broadening of legal aid to victims or families of victims of custodial deaths, needs to be developed, and we need to think about the strategies to build such a legal aid support network. So I'll stop there. Yeah.
Great. Thank you very much, Anup. Yes, absolutely. I mean, so we've heard about the importance of legal aid. We've heard about the importance of data. We've heard about the importance of investigation. And one of the common themes that's emerging across all three countries that we've looked at now, and the diverse context that Ambika also pointed out in her presentation, is this idea across the region where torture is such an inherent part of policing, and how there's a culture of impunity around it. So I'm wondering, I mean, from the three of the speakers that we've heard today, and we'll come to the audience questions as well, how has your engagement been with these frontline law enforcement agencies? Because clearly there is a problem of impunity. There's a culture where torture is not being condemned, both by the public, but also within the organizations themselves. So maybe I start with our first speaker, Sarah, and then I give an opportunity to the other two to think about the responses as well. Sarah, you have the floor. Please go ahead.
Yes, thank you. It's been a journey. And again, you have to realize the nature of the state institution that you're trying to engage with. So when we talk about the police, so we believe in capacity building. Each of these, we bring them on a multi-platform to get them out of their silos situation so that they talk to each other, right? The medical community, the judges, all of these guys. But then when it comes to training and capacity building, I hate calling it training and capacity building because it's more about changing hearts and minds, kind of like what Ambika talked about. We try to do that through specialized resources. For the police, when we were piloting this e-course, the Ministry of Human Rights asked us to do this for the police academy. And we said, look, we'll pilot it, but we think it's going to be a crash and burn no matter how good the course is. Because, you cannot provide training or, change that culture unless you're, also giving them a viable alternative to do their job. Right. So for a lot of police officers who have, I am not taking their side in the least, but this is the kind of empathy that we have to project during that time that you're engaging with them. For them, with 1,000 cases, no money, shifts, et cetera, et cetera, et cetera, long shifts, no resources, no training to do investigations, something like the Mendez principles is an excellent tool that provides them an alternative and effective method. Now, again, the problem becomes I cannot teach the Mendez principles to the police. It has to be by a police officer or some expert so that they can speak their own language. Same with the medical legal community. You can tell them about the Istanbul Protocol and all of these protocols, but in order for it to truly be like kind of institutionalized, they need to have specialized trainings by people that are trained or potentially their peers, maybe from other countries, especially from the region, that can speak to the practicalities of what they face while reinforcing these standards. And then the third part is the tools. The tools that you give them. I mean, what's brilliant about what Ambika was speaking about, and she just got herself into a lot of trouble because now I'm going to drag her to Pakistan to create the same tools for our commissions. And we've got the National Commission and several other commissions. And this is exactly the kind of practical stuff we need. More than giving them just a training, each time they're going to do that detention visit, when they don't have that much time, they don't have that many resources, checklists, SOPs, et cetera, et cetera. And again, speaking to what, and this I'll end with this, what Anup was saying about, we rely on our National Commission to also gather data. But how, and they get thousands of calls on torture and complaints of torture. But when we looked at and we're working with them and we're kind of stuck because we're trying to figure a way, the best way to do this, how they have those complaints taken in, reviewed, and documented, and then redressed. Apart from an Excel sheet or something that's just like, to develop a truly meaningful complaint mechanism that is not burdensome but useful for the commission to fulfill its aims is going to be really important. So I think that's how you change this hearts and minds question, right? I think it's, I mean, I agree with what Ambika is saying. We have a culture of violence that begins in our schools, right? That starts in our homes in South Asia, where you're allowed to smack your kid or, in any place. But in order to change that, I firmly believe in working first with like these state institutions, because at the end of the day, when you're in a police station, you might experience violence, or you will experience violence if you don't come from a certain kind of background, or you don't have means, but you do know it's wrong. You don't know. I think the acceptance comes from the futility of doing something about it. So in that sense, more than public awareness, we try to do public awareness around the act because the public doesn't even know that exists. But we kind of focus on state institutions, and the process of changing their hearts and minds is through a journey of providing them these practical tools that allow them to do their job in a different way, perhaps.
Great. Thanks, Sarah. And before I turn to Ambika and give her a chance to accept or reject your invitation to come to Pakistan, I just wanted to read out some great questions that we're also getting from the audience. Mr. Damilola Decker from Nigeria writes that his experience training law enforcement in Nigeria also revealed to him, very similar to what all the speakers have said, that police officers are routinely resorting to torture because there aren't adequate forensic investigative tools at their disposal. And they've also struggled in Nigeria to convince law enforcement officers that torture should never be an option in solving crime. And the question that he's posing to the speakers is that how can we convey that message effectively and convince actually people, but also particularly law enforcement agency, that torture is not an effective tool. So I think it's very similar to the discussion we're having today. And yeah, Ambika, I turn over to you. Please, you have the floor.
Thank you. In response to what Sarah said about the commission, yes, you know, streamlining and making the internal processes of a national commission is really difficult, and particularly also if the commission has not been independent for a very long time, and then you come in and you're trying to do institutional structural reform. It is challenging. I'm quite happy to have a conversation with you on that. 3 points. Firstly, that, you know, where the difference I saw was when the government changed, and if the government had a zero tolerance policy on torture and they were serious, we would see what we would see was not a huge reduction. What we saw was not a huge reduction in the complaints of torture, uh, but that people started complaining to us about torture. Media started reporting more about torture. Police officers were more amenable to us summoning them, turning up for inquiries, etc. So that did have an impact, although the number of complaints we received actually did not go down. So that is interesting. Second point is that the institution of the police itself is violent. Violence is embedded and intertwined with the structure. It's structural, it is systemic. This also means that police officers themselves are subject to different forms of violence, including from their seniors. I have witnessed police officers, junior police officers being verbally abused by senior police officers. I have received complaints from women police officers of sexual harassment and sexual abuse by their colleagues and their seniors. So I think the police themselves, they are also officers, particularly at the lower levels, are subject to, you know, terrible pay, terrible working conditions, as well as abuse and harassment. The third thing is about protection through presence. It does work. My experience is that because we started going into prison so regularly, what we saw was actually a reduction in violence. So much so that the incarcerated persons told us, please establish an office of the commission inside the prison, because when you guys are here, they don't hit us. The food quality of food is better. We have access to water, like, you know, the 12 hours that you're here, we have access to water. So please establish an office. The superintendents and the chief jailers would tell us, and I've actually, even they've told me half jokingly, half seriously, you know, because you are coming here, because of the commission, we can't maintain discipline, because when we try to maintain discipline, they immediately say we are going to complain to the Human Rights Commission. So protection through presence is important, but it's effective only if you do it consistently and over a long period of time, because even 2 or 3 years is not enough to change minds. I think it would have to be 5 years or more than 5 years consistent monitoring like this, and also taking the complaint seriously, holding inquiries, summoning the officers, issuing recommendations. All that does have an impact in changing institutional culture.
Great. Thank you so much, Ambika. Absolutely. I mean, especially for stressing the point that we need systematic change and creating mechanisms, reliable mechanisms for accountability to start changing this broader culture that we see around the region for violence and torture, especially within the policing institution. So coming to you, Anup, I also want to read out some of the questions for the chat, because the question and answers are blowing up, and we're really grateful to our audience who seems to be joining us from countries all over the world, even outside the same region. This is exactly the point of this webinar, that we really want to create a platform for action and joint advocacy. So we're really pleased to see this kind of engagement. So one of the questions I think comes from the Netherlands, where Miss Amy Laura Sinclair is asking, what methods have you found most effective for documenting torture in ways that are actually influencing policy and public opinion? Now, I know, Anup, you have a lot of experience on this, so would love to hear what you say. And then the next question, which is from an anonymous attendee, also is related. It says, how can we bring a systemic change in a society where not only law enforcement, but also the public believes that torture is acceptable? So yeah, now I hand it over to you.
No, I just want to quickly respond to some of those questions and say that, I think documentation, empiricism, laying that out in terms of data is extremely important, but we can't stop there. We have to combine it with effective public storytelling, right? Otherwise, you end up speaking to the choir, you end up speaking to the converted, right? And so just doing empirical research and presenting it to audiences that already, are familiar with that will be the reality is of no help. But I think we need to make that leap of saying, how do we convert this into strategies that can affect public perception of torture, the extent of it in our systems, and also why it is a terrible legal phenomenon and a social phenomenon. And I think that tough part of storytelling is something that we don't deliver too well on very often, right? On the second part, I think there was a question about resolving to forensic methods. I think one of the questions I saw, right? I think we need to be careful here that there's, at least here we are seeing a push towards more and more forensics as an supposedly a systemic answer to custodial torture, right? But what is happening is nobody is paying attention to the quality of what kind of forensic evidence are you bringing in, right? So while it is being sold as the antidote to custodial torture to equip our investigating agencies and our forensic labs, but what is coming in through that is a lot of dodgy forensics, right? So unless we try and solve that problem as well, we are going to just create a whole lot more issues where we're going to get a lot of unreliable convictions based on false evidence, right? On false forensics. But I want to make a larger point, Zainab. I think look, at least in India, the idea of police reforms has been on since the colonial times, right? It's almost like more than a century old, this effort, right? So while I'm all for, and I think we have to keep chipping away at institutional reform and institutional culture, and that is where I agree the real solution lies, the long-term solution lies. But I think we just haven't concentrated enough on what is the legal support being provided for accountability in individual cases. We need to start developing that pressure point as saying that these will be prosecuted, right? And that assistance needs to be provided to prosecute these cases of custodial deaths. And that pressure point needs to be developed in a systematic manner, right? Otherwise, we are going to keep seeing, and at least in India, we've seen some instances of custodial deaths evoke so much public outrage, right? Saying, how can the cops do this? Whereas there are other instances of custodial deaths that result in such hero worship of the people who have inflicted those custodial deaths, right? Absolutely. And that disjunct in morality sometimes is very hard to explain, because I think there is no fundamental public commitment to the underlying first principle that all custodial violence and custodial deaths are wrong. It is very much a moral assessment of who is being subject to this custodial death. If it's the good person, the innocent person, yeah, then we will feel outraged. But if it's this bad bunch of people who've been accused of rape and murder, then may as well kill them. It's okay for the police to kill them, and let's garland them and let's celebrate them. But yeah, a lot of public messaging work, I would think. Yeah.
Great. And I know that Ambika and Sarah want to jump in, but we really have to move on to our next panel. But there will be an opportunity for a discussion with the entire lineup of speakers at the end. So I just request for your patience. And I'm really pleased on this note. I want to thank the three speakers on this panel, and I'm really pleased to move on to our next block of speakers. So we've been talking about the systemic issue of torture and the accountability across the region. And I think because this is the International Day for remembering the victims of torture, we have to acknowledge that while torture is systemic, the brunt of the torture and its impact is borne by marginalized communities and vulnerable groups. And this is something that Ambika also alluded to, and it's something that we see across the region. So on this note, I'm really pleased to introduce our next speaker, and that's Miss Duaa, who is from the European Saudi Organization for Human Rights. She's an advocacy professional and she's a researcher who's been looking at the violations of human rights across the criminal justice system in Saudi Arabia. And she's had a focus on prisoners on death row, especially on foreign nationals who've been sentenced to death. So, Duaa, you have the floor. I'm just going to pin your profile. Yes, please go ahead.
Thank you, Zainab. Thank you for the organizers for hosting this important session. I truly appreciate the opportunity to share this panel with all these experts. As Zainab said, I represent the European Saudi Organization for Human Rights. We have documenting and advocating against human rights violations in Saudi Arabia, focusing on right to life, torture, process violations, and systemic discrimination, including cases involving arbitrary detention and execution. Saudi Arabia is one of the world's largest host countries of migrant workers, with millions of foreign nationals living and working there. These individuals come from a wide range of countries, including Pakistan, India, Somalia, Ethiopia, and other nations around Central Asia and East Africa. On the contrary, our documentation reveals a systemic pattern of abuse targeting foreign nationals from the moment of arrest when they are in the judicial system, from the moment of arrest through detention, trial, and even post-sentencing. And today I will try to highlight key aspects of these violations and the serious accountability challenge that remain unresolved, especially in this day, International Day. Actually, testimonies and reports from human rights organizations reveal a systemic pattern of discrimination and abuse against foreign nationals in Saudi Arabia's detention centers. These violations, as I said, started from the arrest. So from the arrest, foreign nationals are denied from basic legal safeguards and subjected to discriminatory treatment based on their nationalities, so that they are denied of the right of translators, preventing them from understanding the charges or the causes of the arrest. Also from beating and torture during the arrest, often without a cause or any, of course there is not justification, but even not for getting confessions and so. In some cases, we have documented that enforced disappearance lasting for months, during which detainees are cut off entirely from the outside world. Families just ask about their beloved one who were assumed to go to Saudi Arabia just to work. During the investigation also, we have documented physical and psychological torture, including beatings and humiliation. Also, denial of communication with lawyers or family members, violating international standards. We have cases of detainees that did not contact a lawyer during all the trial. Also, forced confessions, often in languages the detainee does not understand, and signing documents without knowing their content. Unfair trials and arbitrary sentencing. Trials of foreign detainees often fail to meet minimum international standards of justice. So there is lack of legal defense during all the legal process, as I said. And there is unfair and arbitrary sentences, including death penalty based on the confessions without the fair trial. Even after sentencing, abuses continue inside criminal prisons, such as we monitor severe overcrowding and inhuman conditions, detention beyond the completion of the sentence without legal justification. In the death penalty cases, there is psychological torture without knowing the executing date, without giving the family member any timing or the right to say goodbye, and the family member are further traumatized after the execution without knowing the place and without getting the place of the body and without getting the right to say goodbye to the body or to burn the body. I just want to share some numbers. Till today, we have 162 execution in 2025, only 167, sorry, executions only in 2025. 50% is for foreign nationals. So we have, according to our monitoring, we have 58 execution for foreign nationals from many countries. Unfortunately, the number of foreign nationals and the percentage of the foreign nationals from the whole number of the execution in Saudi Arabia year after year is becoming bigger and larger. Between 2010 and 2021, Saudi Arabia executed foreign nationals in drug-related cases a rate 3 times higher than Saudi citizens for the same charges. This reveals a discriminatory use of death penalty and highlights the deep fragility of legal safeguard of foreign nationals. Unfortunately, Saudi Arabia don't have a real process of investigation and putting on accountability, even though Saudi Arabia is a state party of the UN Convention Against Torture and officially denies allowing torture, but there is no serious complement mechanisms available for victim. In rare cases where complaints had been filed, but mostly from Saudi nationals, investigations were conducted by the state-controlled Human Rights Commission, but no prosecution or any actions allowed to accountability. Embassies and consulate for migrant and for foreign nationals, especially the countries that are sending a migrant worker, often fail to monitor or intervene in cases of abuse, offering little or no protection or support for their nationals. And of course, there is an absence of independent civil society in Saudi Arabia, which further limits documentation efforts, survivor support, and any kind of accountability. The torture in Saudi Arabia is something that every detainee, it's very wide used in the legal system, but we can see more and more discrimination and used more discriminatory way with the foreign nationals and especially migrant workers.
Thank you very much, Dua. I think that was really a very concise but also very informative summary of the plight of foreign nationals on death row and how all of these issues are so strongly interlinked with torture and cruel and inhuman and degrading treatment. And I think it really underlines the importance of regional coalitions like the Same Network, because as you mentioned, that a lot of the people on Saudi Arabia's death row are in fact from a lot of the countries that are represented here today. So on this note, I'm really happy to turn to our next speaker, who is Mr. Mahmood Amiry-Moghaddam from the Iran Human Rights. Now, Iran's been on the news quite a lot lately, and so we're really pleased that Mahmood can join us. I just couldn't add yeah, great. Here you are, Mahmood. So thank you so much for joining us. Mahmood is the founder and I think the executive director of Iran Human Rights, which is an organization that documents human rights violations in Iran and also underlines the need for increased accountability. And they have a special focus on the criminal justice system, where they've also been doing some impressive work on Iran's death row. Mahmood, you have the floor, please.
Thank you so much, Zainab. And good morning, everyone. Thanks for inviting me here. As Zainab said, well, Iran is going through a very turbulent period. And of course, we are very concerned about the human rights situation because very often and almost always, human rights issues come in the shadow of military conflicts and wars. And I think authorities very often exploit that. So I'm happy that the military operations have stopped and I hope that the world will put more focus on human rights situation. I will not be very long. I think there are many similarities between what Duaa said and the situation in Iran. And as you know, torture is multi-layered. The definition of torture. It's very broad, and I hope that we can be able to create awareness about all these layers. But today I will just point at some issues. First of all, torture is being used systematically in the Islamic Republic of Iran. Basically, during interrogations, since the main way of proving guilt is confessions, in capital cases, during these 20 years, we haven't met one single person sentenced to death who hasn't been tortured to give a confession. So that's systematic. I would also like to point out that in the Iranian law, in the constitution, torture and forced confessions are banned. So basically, this practice is illegal. I'm not going to talk about parts of the penal code that, the punishments that amount to torture. For example, we have lashing as a punishment. We have amputation. We have stoning, although it hasn't been practiced. So we are not going to talk about that part, but only the torture that actually is banned according to the law. And I want to show you just some examples of both, examples of cases and also lack of accountability in the Iranian judicial system. So I think I can share, right? Yes, I do. And so here, let's see.
No, I don't think. Oh, we see.
Can you see my screen now?
Yes, we see it.
So this is our website. I hope that you can visit it. On the top, we have the execution counter. So far in 2025, we have 594 executions, and this is in the last 10 years. This is the minimum number that we have managed to confirm. And then you also have different cases. Yesterday, 3 people were executed for collaboration with Israel. 2 days ago, another one, and then in the last, since the beginning of the war, at least 6 people have been have been executed for collaboration with Israel, in addition to others. But back to torture, there are some cases where we have more documentation about how torture has been used and how the system, the impunity in the system works. Navid Afkari, the gentleman here, was a protester. He was arrested in the August of 2018 and sentenced to death for a murder. In this case, we have a lot of documents. I mean, this is one of the few cases that Iran human rights managed to get access to all the court documents. We had voice recording from the trial, during the trial, and also there was a whistleblower. So I come back to that. So what happened in the court documents, it was written clearly that Navid has claimed that he was severely tortured to confess to a murder, and with the details. And then the voice record that we access, all this was smuggled out. Part of the conversation between Navid and the judge is that Navid says, "I was tortured," and the judge asked him to shut up. And then he said, "Actually, I heard that in some cells close to me, somebody was being threatened to rape." And the judge says that, "Okay, be careful that that doesn't happen to you." And then there was a whistleblower, a financial, somebody who was sentenced to prison for financial crime. So he was not political prisoner, but he had observed. He said that I was being transferred, and then we went past a room. The door was not completely locked, and somebody was being beaten, and suddenly he screamed, and I think they broke his arm, and then he later found out that it was Naveed Afkari. So all these documentations were available, and so that led, after Naveed was executed, we published, of course, also the days before his execution, all these documents, and the Iranian judiciary, they were forced to come with an announcement basically denying everything without any further investigation. And that's what we are very used to. So there is no, not even an investigation, trying to do an investigation. And the few times there have been investigations, it's part of the authorities, the organ, no independent investigation to torture claims. So nothing came out of the judiciary, no response, but the person who had witnessed, the person who was sentenced to imprisonment for financial crimes, Shaheen Nasseri, on the anniversary of Naveed's execution, he died under suspicious circumstances. He was completely healthy. He was transferred to solitary confinement and was dead, found dead, and the authorities said that he had taken an overdose of medications, and no independent investigation into his case. And according to our sources, Shaheen was going to write or read a voice message on the anniversary of Naveed's execution, but he died, according to authorities, due to medication or overdose of medication. He was completely healthy. And again, no investigation whatsoever. So this is, one case where we have a lot of information with, documentation, written, sounds, and so lack of impunity in the Islamic Republic is probably one of the biggest obstacles to reaching justice and improving human rights. Another thing which is very, very common is for the political prisoners, and now that we are in a period where we will be facing many people executed for espionage for Israel. Basically, hundreds have been arrested in the last days. Ismail Fekri, who was executed last week, we have more information about his case. His trial lasted 10 minutes, and he was tortured, but beside that, he was threatened that his family will be arrested if he did not confess to working with Israel, something that he did. These are information that we had before his execution, and he was executed. But torture and forced confession, as I said, is not only in political cases or security-related cases, but also in ordinary, like common crimes for murder, for rape, for drug offenses. And as I said, we know no one on death row who hasn't been subjected to torture. But you see, sometimes this is not considered as torture. I remember I was talking to a death row prisoner. Of course, the way we do it is secret. And I asked him, were you tortured? He said, no. I say, wow, so they didn't beat you? Oh yeah, they beat me a lot because they wanted a confession. But he didn't consider being beaten in the police custody as torture, because they had a picture of torture with specialized instruments. And so one thing we need to do is create awareness about what is torture. But one case that came into Iranian media, this is a Iranian newspaper that published a very happy news that a man was proved innocent 48 hours before his execution. And then, it was a happy news. So the journalists interviewed him, how do you feel? And he was happy that he wasn't hanged. And they say, but why did you confess to a murder if you were innocent? He said, they beat me so much that I thought I will die here if I don't confess. And the article stops there with this good notice. Nobody followed it up. That okay, forced confession is banned according to the Iranian law. Why nobody followed it up? Why didn't they find out, okay, who was torturing you? And because he said that I also say to the judge that I was beaten to confess. But so this systematic torture and lack of impunity is institutionalized, and I think unlike my colleagues in Pakistan and India, where you have ways to go through the law, and unfortunately, the means that we have in Iran are much more limited, because we cannot go through the judiciary, because judiciary is part of the it's not independent. So what we need to do is to create awareness, to build international pressure through UN agencies, through countries with the diplomatic relations with the Islamic Republic,
Mahmood,
and
sorry, I'm sorry, I
also
have to
people.
cut you off because we
Yes,
are
I'm
running.
done now.
Yes,
I'm done.
thank you so much.
Thank
And
you.
thank you for sharing the powerful testimonies of survivors and victims of torture, and really incredible work to collect them under such challenging circumstances. And obviously, the people of Iran are in our hearts across the same network, and I'm sure for a lot of our audience as well. So this brings me to our final speaker. And just a reminder for the audience that after this speaker, we will have another opportunity to come to your questions. So please do type your questions in the Q&A box at the bottom of your screen. So we've heard about international advocacy and the importance of UN agencies in engaging across the same region, because, as Mahmood also highlighted, it has some of the worst records of torture and some of the weakest accountability mechanisms for survivors, for perpetrators, but also the weakest remedies for survivors. So our last speaker is the Honorable Aisha Shujune Mohammed, who is a member of the UN Subcommittee on the Prevention of Torture and Other Inhumane and Degrading Treatment. And this is her fourth term on this committee. So we're really happy to have you, Shujune. And can you tell us, how do you see the value of international mechanisms such as the Convention Against Torture and the optional protocol on the Convention Against Torture for whatever you've heard across this region? Like, how do you see the force and the power of these international mechanisms in creating a difference across this region? Please, you have the floor. Thank you so much.
Thank you, Zainab. It's an honor to be here with you today, and it was very interesting to hear from counterparts from across the region share their experiences. Unfortunately, Asia has the lowest number of OPCAT ratifications. OPCAT is open to ratification to those countries which have ratified CAT, the Convention Against Torture. OPCAT is an extremely unique treaty, and I will lay out what it is about and why it's of immense use, especially in a situation like ours. And perhaps we can collaborate and advocate for ratification. Well, what OPCAT creates is, while CAT defines torture and reiterates its prohibition, what OPCAT creates is an international and national visiting regime, which allows SPT as the international visiting body and NPMs, national preventive mechanisms, as their domestic counterparts, to visit places where people are deprived. Because realistically speaking, SPT as the international body cannot be at different locations all the time, whereas the national bodies can. So we work in conjunction with the national bodies, and we provide advice and assistance to them as needed. So the work done by OPCAT is confidential. under OPCAT is confidential, so unless otherwise approved by the state parties. Because what the OPCAT allows us to do, the SPT and the NPMs, is unfettered access to places where people are or may be deprived of liberty. The definition of a place of deprivation of liberty is extremely broad. We have the first general comment out already. It's not confined to conventional places of deprivation of liberty like police and prisons. It can be social care homes, it can be juvenile facilities for care, it can be migration centers, it can be like places where people are kettled, say, for example, during protests. So a place of deprivation of liberty, the definition is extremely broad. The powers and mandate of the SPT and NPMs are to access all these places of deprivation of liberty, places where people are or may be deprived of liberty, to speak to people detained there, to speak to officials who work in those places, to look at all the facilities, to look at all the documentation. That is the agreement we have under OPCAT, which is why the trade-off of confidentiality is there, because we do understand oftentimes places of deprivation of liberty are not the most pleasant, and it's where a lot of secrets lie. So that is the trade-off. But having said that, the OPCAT mandate is purely preventative. It's not reactive. It does not investigate cases of torture. Rather, it looks at systemic issues. The mandate is actually threefold. It is, we have a visiting mandate, we have an advise and assist mandate, and a cooperation mandate. Of course, the primary one being unannounced visits to places. Like I said, there is a broad definition. So once we are, because of these access we are able to look at the entire normative framework, how it works at the ground level, including how it impacts people, what works, what doesn't work, what can be improved and enhanced, and what should be done away with. And because OPCAT does not introduce new standards, the regime created by the treaty is purely to ensure that risks of torture and ill treatment are minimized. And this is done through advice and recommendations to state authorities after having looked at situations and things firsthand, so that the reality can be catered to. Of course, this also means that it attempts to address the issue of torture before it occurs. And we look at, among other things, safeguards in place, due process aspects, etc. What it means is that through this, dignity may be restored and abusers can be averted. And of course, because prevention at the end is far more cost-effective and respectful to human dignity, the benefits is not only to persons in detention, but it is also to the custodians and the state party in general, if a country were to ratify. Like I said, only a very few states in the Asia-Pacific region are party, but being an Asian myself, I understand oftentimes, I'm not justifying it, I understand the hesitation owing to our cultural histories, etc. But ratification has its advantages, and this is something civil society can also work with. Countries.
Thank you, Shujune. Can I ask you to wrap it up, because we also want to have some time for Q&A?
Yeah, just 1 minute.
Yes, of
we
course.
can then have countries can receive advice as to how standards can be met. And because all the other treaty bodies will also be making recommendations vis-a-vis torture, inhuman treatment, once and OPCAT ratification, among others, those things can be crossed off in one swoop. And the advise and assist role will kick in. And most importantly, it allows states to ensure that torture and treatment are prevented. And all this can be done confidentially. So that's it. Thank you. Sorry.
Thank you so much. And so sorry to cut you off, but we have a lot of questions from our audience that we want to get to. But thank you for highlighting the importance of international mechanisms like the OPCAT in ensuring accountability domestically. And I think we've heard from a lot of our speakers how it's so important for the UN agencies to remain involved in the accountability and monitoring of torture across the region. So we've had a really great discussion from an amazing panel of speakers. We've heard about systemic issues of torture. We've heard about a lack of accountability, a lack of independent investigation mechanisms. But we also heard how different countries are adopting protocols, a lot of them based on international standards to create more accountability, but also to sort of reform this culture of violence and torture that affects so many of our countries today. And then from Mahmood and Duaa, we've heard about firsthand narratives of survivors and how torture impacts the most vulnerable groups, and how in a lot of countries, survivors have such little mechanisms where they can seek any kind of justice. So we've heard such a diverse collection of views. And I really want to give another chance to all of our speakers to share maybe something that they weren't able to raise in their remarks. And I see also from the Q&A from our audience that there's a lot of pending questions from our audience members, and I'm sure they would love to know more about from the members of the same network. So just looking very quickly, maybe the first question is for you, Ambika, is can you share a bit more of the protocols that you have been using in our work, and what do you see as the role of international standards in formulating these protocols? So Ambika, please, you have the floor.
I mean, your second question first. I think we do what we base everything on are the international standards, right? Because that's the benchmark. But as I said, to come back to my original point, is that yes, so we have these manuals, we have the standard operating procedures, but the success depends on many factors. It depends also on whether a commission has competent staff. It depends on whether the commission has the power to hire the staff they want. It depends on whether the staff, the pay grade of the staff, are they paid enough? Are you able to hire competent people at that level of that standard of salaries? And also, for instance, at the HRC, one challenge that we faced is that the staff that were there when we were appointed were staff who had been hired during the previous regimes when the commission was not independent. So therefore, there was also, the culture, institutional values. And as I said, it's it's really difficult to change that even in 5 years, is what I realized. So I would say the success of all these protocol structures, systems, methods ultimately depends on values and institutional culture and societal values, and whether the state is actually committed to a zero tolerance policy. I mean, to go back to what Anup said, about this police reform being on the agenda in India for decades. Same goes for Sri Lanka. There's a report from 1965 of a police commission. If you read that report, it's like you're reading it now in 2025, where police violence is concerned, which shows that it's deeply entrenched. It is systemic. So we cannot focus on quick fixes, because the reality is there aren't quick fixes. The other general points I want to make is that to conduct effective detention monitoring, the National Commission requires rapid response units, right, that can respond to complaints of torture immediately and not a day or two later. We had a problem with this. For this, the commission requires financial resources, competent staff, both of which many NHRIs in our region lack, including lack of independence. The other, I think, 2 points goes to what Anup said. One is about when society thinks that torture, in certain instances, they're horrified. In other instances, they're very supportive. And this goes back to how certain populations are criminalized, they're securitized, and they are demonized, which means that any state abuse of those populations is accepted, which is why this analytical framework that I keep bringing up repeatedly, which is criminalizing poverty and status, that helps us break all this down and to see what the actual problem is. It helps us see how the state does this. What is the strategy the state uses? Finally, where support to victims are concerned, in our region, there is a lack of legal aid. We see that across our region for victims to challenge these the violations. Also, because many, at least now, for instance, in Sri Lanka, many are now not interested because the system, the process itself is abused, is traumatic, and they feel that they receive nothing at the end of it. They don't receive justice. So there is a huge reluctance to challenge this and to file action. Finally, the UN Voluntary Trust Fund for Victims of Torture, of which I'm a member, it provides grants to civil society organizations to provide support to victims, ranging from psychosocial to legal, and also training, capacity building, etc. Except, of course, the fund also is in a precarious position now due to all these funding cuts. But hopefully, we can continue. And I would encourage civil society partners to also submit applications. Thank you.
Yeah, thank you so much. And lots of lessons here for a lot of great cross-country learning, but also cross-country collaboration from across the region. And I think one of the things that keeps coming up is like this culture of violence. But one of the things that we also see across the region is this culture of like art and advocacy. And that's something that's been really strategically instrumentalized by a lot of our partners who are joining us today. I know that, Sarah, you wanted to say something about the power of art in changing the minds, and that's something that JPP has had experience with. Please go ahead.
Yes, so I would just put the earlier part when we were talking about changing public perceptions. And there was a question, I think, in the chat about how do you change public perception in a place where the public is almost kind of in favor of it or has accepted it, etc. We found large scale public advocacy. We always try to place that burden on the government and to push the government to do it because there's absolutely no comparison between, a CSO trying to do it and them trying to do it. And I think it's really unfair because the burden is shifted to us and then we say, yeah, but no, it's the job of the government to do it. We didn't get born to like fix your problems on public perception, you know. But what we have done that we found to be quite powerful and useful is arts through the advocacy. So we collaborate with artists and on different projects and local artists, sometimes with international ones, and we design immersive experiences. So one of the things that we did recently that was on torture, this doesn't mean you guys have to do that, but it's just to give you a taste of when we do engage in public advocacy. We had an escape room that was called Caught, but it was, in a movie studio that was outside one of the old leftover movie studios. And the job was that you were first day on the police as a recruit. And so you signed up as a group, and then you went from room to room to try to solve a murder case. And the whole unraveling was this kind of tension that was built into the entire game was that as you are trying to solve these clues, with the police officer in charge, you start to notice little by little as you solve each clue in each room, is that you're unwittingly participating in a violation. So they'll say, like, you have to find this document. So you have to solve a bunch of puzzles and file the document. When you find the document and when you find it and you hand it over to the policeman who's in charge of the investigation, he'll say, well done, and he shreds it. Right. And now you have to move on to the next one. So it was exploring this tension between, and challenging the public perception of police investigations. And the whole thing ends with torture and a confession, et cetera, et cetera. Look, it was expensive, but it was something that we were able to mount again and again. And the response that we got from it was incredible in terms of, these immersive experiences. And I understand that other CSOs around the world don't have to begin with this, or, they'd be like, where on earth do we even start? But we've been doing this for 15 years, and it was born out of necessity, many years ago. And we're happy to give it to you, we'll help you. You can take the stories, you can take the problems, indigenize them. We'll tell you what the process is of working with artists. But we're very big believers in that. And it's really not on a scale that the government should. But we found these kind of immersive experiences. They can be small. We started off with one box a long time ago to be really powerful tools for changing public opinion. We also made parliamentarians go through that game, right? So that they get that idea. So, yeah.
Thanks, Sarah. No, and I think it shows that sometimes we rely so much on, as lawyers, because there's a lot of lawyers in this room, that we rely so much on legal argument and the perfect cases and precedents. But really, at the end of the day, changing people's minds through advocacy just requires a bit of creativity and art. I mean, you can't replace it, especially across the South Asia, Middle East region. It's
Also, no one
such
likes listening to lawyers. I
no,
mean,
nobody likes lawyers.
listening to lawyers. Let's
Only
be
lawyers like listening to ourselves. But yeah. So Shujune, you want to come in, and then maybe because we don't have a lot of time left, after Shujune, I would invite any of our participants to talk about their experiences providing support services to victims of torture, because this is the International Day for Remembering Torture. Please go ahead. You have the floor.
Thank you. It's also Shujune.
Shujune.
All right. Anyway, no, I just wanted to chime in about the perceptions. And one of the things I found out, whether it was working with police, prison officers, judges, prosecutors, or even just average common people, public, is that when you talk to them about human rights and ask them to confront their personal biases, that becomes a moment in which a shift occurs. And that is something you can bank on. So asking about personal biases and to confront the personal biases, why you have these biases, and unpacking all that, I've found becomes helpful. And then an interjection comes, say, for example, if you're working with the police, to talk about the Mendes principles and why that obligation is there. If it's with the prison authorities, about the Mandela rules, Bangkok rules, and why that obligation is there, and why you are then responsible for X, Y, and Z, and that you will then otherwise be held accountable. You turn the table around, but then it's a bit of a build-up. But it can work, and I've found it works quite well, actually. Thank you.
Thank you very much. And yeah, I mean, to wrap it up, would anybody like to share their experiences providing support services to victims of torture and what's worked? I know it's such a big question to pose at the last 5 minutes, but I think it's a great note to end this valuable discussion on.
I don't think if
Yeah,
I can
please do.
jump in. Thank you, Zainab. I'm just jumping in that even in Saudi Arabia, with all the difficulties that we are facing and all the struggling and even monitoring and getting the stories of the victims, we have some strategies that can help. For example, getting stories from the families of the victims, especially with the foreign nationals, as if this group, actually, this network is one of the ways to reach for stories, for example, from Pakistan, from India, and that we can retell what's happening and try to advocate through these stories to make changes and try to help others that are facing the same situation. And also the UN mechanisms, contacting these UN special rapporteurs, the committees, putting the countries, states such as Saudi Arabia and under their commitment, as they are part of, for example, the UN committee or any other commitments they put themselves on. So using these mechanisms is always a way, even in countries such Saudi Arabia. And also trying to advocate and to raise awareness for the people that even it's sad and even of this darkness and the continuous torture, it's always good to tell what's happening and to talk about what's happening with the NGOs, with the media, with any ways that can highlight the torture stories. I think it's always important to raise awareness to the victims themselves and their families. And thank you.
Great. Thank you so much. And I think this was a very powerful note on which to bring our discussion to an end. I mean, I wish we could go on forever given the wealth of knowledge in this room, but I think I've received a warning from the organizers that we have to close the webinar. On this note, I really want to show my appreciation for all of our brilliant speakers who joined us here today. Thank you so much for taking out the time and joining this important discussion. And especially to our audience who seems to have joined us from different parts of the world for sharing your questions. We're really sorry that we couldn't get to all of them, but we hope that as this network, which is the same network, we continue to host these moments of learning and action so that we can keep sharing our experiences and give more and more opportunity for engagement across the region, but also learn from people from outside the region. So we're really grateful that you joined us today, and we hope to welcome you to future advocacy opportunities as well. Yeah, and I think I would like to uh, point out that our network is growing and we're open to having new members. So if you would like to join our network, join the cause, please reach out to us and we would be happy to have you. And please look out for more information from us. And on this note, thank you also to OMCT and the Secretariat of Global Week of Torture for giving us this opportunity. And yeah, thank you so much, everybody. And we wish you a great day and a great week.
Bye. Bye.
Bye.